Hello friends, welcome to UGC E-PG Pathshala. I am Dr. Rangeen Pallav Tripathi. I am a faculty of law at National Law University, Odisha. Today, we will be discussing the module on right to pre-sentence hearing. The basic objectives of this module are the following. To understand the significance of sentencing in the criminal justice process, to understand the law in India regarding pre-sentence hearing under section 235 subsection 2 of the Code of Criminal Procedure, to understand the law in India on pre-sentence hearing prior to section 235 subsection 2 of the Code of Criminal Procedure, to understand the implications of section 235 subsection 2 on the trial process, to appreciate the scope of evidence which is permissible to be produced in a pre-sentence hearing, to have a basic grasp over the nature of facts which are relevant in a pre-sentence hearing, to appreciate the consequences of not complying with the mandate of section 235 subsection 2. Let's start with the significance of sentencing. Much of the criminal law, both substantive and procedural, is dedicated to the determination as to whether a person accused of a crime is guilty of the same or not. Substantive criminal law defines the various crimes and provides the framework of ingredients which must be proved in a case to hold a crime to have been committed. Procedural criminal law deals with the mechanism and procedures through which such factual ingredients are sought to be proved. Most provisions in the Code of Criminal Procedure and in the Indian Evidence Act are centered around the need to ensure that the guilt of an accused is properly proved. However, the purpose of criminal law is not simply to determine whether a person is guilty or innocent, but to decide what to do with a person who is found to be guilty. The function of criminal law does not end with the mere determination of the guilt of an accused, as it does in case of the accused being adjudged as innocent. Once the accused is declared innocent, the criminal justice system has no further considerations with the accused. But if the accused is adjudged guilty, the criminal justice system has to deal with the most important question of the appropriate sanction which should be imposed on the person so found guilty. Without the imposition of a sanction, there is literally no point to the entire criminal justice process. Thus, the quality, the quantum, and the nature of sentence which should be awarded in a given case is at the core of the entire structure of criminal justice administration. It is in this context that now we'll discuss the law on pre-sentence hearing in India. Section 235, subsection 2 of the Code of Criminal Procedure 1973 provides that once the accused is convicted of an offense and the court is not proceeding on the line of probation, the court must hear the accused on the question of sentencing and then pass a sentence according to law. A similar provision is also incorporated in section 248 subsection 2 Code of Criminal Procedure in relation to the trial of warrant cases by magistrates. It needs to be noted that The earlier Code of Criminal Procedure of 1898 did not contain such a provision, and the same was incorporated into the Code of Criminal Procedure 1973 pursuant to the recommendations of the Law Commission of India in its 48th report. The Code of Criminal Procedure 1973 was a reformative legislation which sought to bring in various measures of updates and meaningful changes in the existing criminal procedure code. While recommending the insertion in the nature of section 235 subsection 2, the Law Commission mentioned, it is now being increasingly recognized that a rational and consistent sentencing policy requires the removal of several deficiencies in the present system. One such deficiency is the lack of comprehensive information as to characteristics and background of the offender. We are of the view that the taking of evidence as to the circumstances relevant to sentencing should be encouraged, and both the prosecution and the accused should be allowed to cooperate in the process. The aims and objects of the Code of Criminal Procedure 1973 in relation to section 235 subsection 2 provide the philosophical foundation behind the enactment of the provision, and they read as follows. If the judgment is one of conviction, the accused will be given an opportunity to make his representation, if any, on the punishment proposed to be awarded, and such representation shall be taken into consideration before imposing the sentence. This last provision has been made because it may happen that the accused may have some grounds to urge for giving him consideration in regard to the sentence, such as that he is the breadwinner of the family, which the court may not be made aware of during the trial. Even before section 235 came into force, the Supreme Court in the case of Ediga Annamma versus State of Andhra Pradesh recognized the importance of this provision, which at that time was considering the lack of comprehensive provision in the earlier criminal procedure code for collection of sufficient personal and social information regarding the offender for an appropriate sentence to be awarded. The Supreme Court in the case of Santa Singh versus State of Punjab has held the provision of pre-sentence hearing that it is oriented towards a socio-economic purpose and towards the goal of attaining an ideal balancing in the sentencing process. The law seems to urge the courts to not simply look at the crime but also at the criminal before deciding upon the sentence. It seeks to trigger a legal adaptation of the modern understanding of the criminal not as a menace which needs to be eliminated, but a diseased mind which must be cured and rehabilitated. In this context, the courts must take into consideration facts which otherwise may not be relevant in a criminal trial. This approach is evidenced by the aims and objects of the Code of Criminal Procedure 1973, which itself mentions about due consideration being given when the person to be punished is the sole breadwinner of the family. Thus, the courts must not simply look at the crime, but also at the background of the criminal and assess the socio-economic consequences and psychological repercussions before deciding upon a sentence. Now let's discuss how did the courts hear on the question of sentencing prior to the enactment of section 235 subsection 2. As was categorically stated in the case of Ediga Annamma versus State of Andhra Pradesh, prior to the enactment of section 235 subsection 2 under the Code of Criminal Procedure 1973, there existed no procedural system for collection of social and personal data of the offender to assist the court in determining an appropriate sentence. The Supreme Court, in the case of Jagmohan Singh versus State of Uttar Pradesh, which was decided prior to the enactment of section 235 subsection 2, had sought to highlight the inherent procedural safeguards for ensuring proper sentencing in India. Though the case dealt primarily with the imposition of death sentence, it sought to explain the several provisions through which an appropriate sentence can be awarded by the court. The court primarily relied on the following propositions: that the accused at the time of being charged is aware of the sentence which may be passed against him and thus attempts to fill the record with as many mitigating circumstances as possible. That apart from cross-examination, CRPC also requires the accused to be questioned in regard to circumstances appearing against him in evidence. The accused also has the opportunity to say what he wants when he is being questioned generally. That the accused and his counsel are at liberty to address the court not simply on the issue of guilt but also on the issue of sentencing. The court felt that though there existed no formal procedure for production of evidence concerning sentencing, all such matters which have a bearing on the sentencing were already before the court. It is submitted that the opinion of the court in the case of Jagmohan Singh versus State of Uttar Pradesh did not do justice to the severity of the problem concerning proper sentencing. This was most aptly expressed in the case of Santa Singh versus State of Punjab, where the court observed that the accused had to make submission regarding sentencing on the assumption that he was eventually going to be convicted. It is not that there was no scope at all under the earlier law for the court to hear the parties on the question of sentencing, but that the available scope was haphazard, random, and uneven. There existed no definitive framework which would induce an equality of opportunity to the offenders of being heard on the issue of questioning on the issue of sentencing. It is in this context that the legislature designed section 235 subsection 2 of the Code of Criminal Procedure 1973, which makes pre-sentence hearing a mandatory element of the trial process. Now let's discuss what are the implications of section 235 subsection 2 on the trial process. As has been noted in the case of Santa Singh versus State of Punjab, the purpose behind enactment of section 235 subsection 2 is to bifurcate the entire criminal trial into two clearly divisible and identifiable phases. In phase 1, the trial process concerns the determination of whether the accused person is guilty or innocent. Phase 2 of the trial process is premised upon a determination of guilt and not that of innocence. In phase 2, the trial process concerns the determination of the sentence which should be imposed on the convicted person. This view was reiterated in the case of Bachchan Singh versus State of Punjab, wherein it was emphasized that section 235 subsection 2 bifurcated the criminal trial into a pre-conviction and a post-conviction phase, with both phases being equally important. Now let's discuss the scope of evidence which can be adduced in a pre-sentence hearing. The pre-sentence hearing is the post-conviction phase of the trial, and as a continuation of the original trial, the accused not simply has the opportunity to make his representation on the question of sentencing, but also has the right to produce such materials before the court which have a bearing on the decision regarding sentencing. The Supreme Court, in the case of Santa Singh versus State of Punjab, has held that the term "hear the accused" in section 235 subsection 2 has been used in the context of providing the accused with due opportunity to place before the court various circumstances which have a bearing on the sentence which may be passed against such accused. For this purpose, the court held that hearing contemplated under section 235 subsection 2 should provide the platform for all kinds of factors to be presented in the court which have a bearing on the question of sentencing. The court held that the hearing need not be continued to merely the hearing should not be confined to merely oral submissions, and the parties are free to place such facts and materials before the court which they feel is relevant for the question of sentencing. If the facts and materials placed on record by one party are not agreed upon and are contested by the other party, then the parties can also produce evidence in support of their claim. This view regarding adducing evidence as to circumstances relevant to sentencing was also endorsed by the Law Commission of India in its 48th report. This view was emphatically reiterated in the case of Bachchan Singh versus State of Punjab. The court held that though section 235 subsection 2 does not make any specific mention regarding adducing evidence and only provides for hearing of the accused, it is implicit in the provision that if either of the parties make a request for producing evidence or other materials having a bearing on the issue of sentencing, the court should grant such permission. The court in Santa Singh versus State of Punjab has, however, cautioned that the hearing contemplated in section 235 subsection 2 should not be abused and used as a modality for undue protraction of the proceedings. The court noted that it has not been the parliamentary intent to provide a platform for delaying tactics under the cover of pre-sentence hearing. The court emphasized that the pre-sentence hearing does not have to be an elaborate scheme of oral and documentary evidence as the pre-conviction hearing, and should be a simple and short opportunity for the accused to place relevant material before the court. If required by leading evidence and a fair opportunity for the prosecution to rebut the submission and materials of the accused. The court stressed on the balance between due and proper hearing on one hand and expeditious disposal on the other. This same caution has also been emphasized in the case of Bachchan Singh versus State of Punjab. Now let's discuss what kind of facts are relevant for sentencing, which are special and different. Once it is established that evidence can be adduced in a hearing under section 235 subsection 2, it is important to note that the nature of facts relevant in a pre-sentence hearing are significantly different than the ones which are relevant in a pre-conviction hearing. Till the time a person is convicted of crime, all facts which have a bearing on the innocence or guilt of the accused are relevant to the parties and to the court. However, for the purpose of determining the sentence of a person who is already convicted, many of such facts may no longer be relevant. For example, the manner of commission of crime may be relevant both for the purpose of conviction and for the purpose of sentencing. However, the social status of the offender or his educational qualifications are not at all relevant in determining his guilt, but may be important information in determining his sentence. Thus, many social and personal facts pertaining to the offender which may not be relevant for the purpose of determining his guilt may be extremely important for deciding upon the sentence to be passed. Due to the difference in the nature of facts which are relevant in a pre-sentence hearing, it also follows that the skills required to argue on the issue of sentencing involves a greater interdisciplinary approach. It requires the lawyer to assimilate into his arguments relative dimensions of social implications, psychological factors, and economic consequences of a proposed sentence. The principles of law applicable in relation to the pre-sentence hearing also vary from that of a pre-conviction hearing. This has been most suitably exemplified in the case of Sevuka Perumal versus State of Tamil Nadu. In this case, the argument before the Supreme Court was against the death penalty awarded to A1. The petitioners argued that since A2 was acquitted from the charge of murder, having been given the benefit of doubt, A1 should not be punished with the death penalty and should instead be given a similar benefit of doubt. The court held that the principle of benefit of doubt operates only so far as the issue concerns the commission of an offense and the guilt of an accused. Once the guilt of an accused has been proved beyond reasonable doubt, the same principle does not control the decision of the court regarding imposition of an appropriate sentence. Now let's discuss the consequences of non-compliance with section 235 subsection 2. It is important to note that the language in section 235 subsection 2 is that the court shall hear the accused and not that the court may hear the accused on the question of sentencing. The requirement of the pre-sentence hearing as mandated under section 235 subsection 2 has been held to be obligatory in nature. Failure to comply with the requirement of section 235 subsection 2 before awarding a sentence will vitiate the final order of the court. Not hearing the accused before the passing of a sentence is as fatal to the case as not hearing the accused before pronouncing him guilty. The pre-sentence hearing is not supposed to be a ritualistic or symbolic exercise and is supposed to be a substantial exercise in the criminal justice administration. The provision of pre-sentence hearing under section 235 subsection 2 are fundamental and indispensable in the administration of criminal justice. Its non-compliance results in implicit and inherent prejudice to the accused. Imposition of a sentence on the accused while completely depriving him of the opportunity to present his case in relation to the proposed evidence is a violation of the principles of natural justice as contemplated under the statutory scheme. The court in the case of Santa Singh versus State of Punjab has held that such non-compliance is not a mere technical irregularity which can be cured under section 465 of the Code of Criminal Procedure and that it will vitiate the entire order. The same was evidenced in the case of Alauddin Milan versus State of Bihar, wherein a sentence of death awarded by trial court and confirmed by the High Court was overturned by the Supreme Court on the ground that section 235 subsection 2 was not complied with before determining the sentence. The court noted how true motive of the murder were never inquired into and other important details like antecedents of the accused, socioeconomic conditions of the accused, the impact of the crime on the community have not been brought on record. Another important facet of section 235 subsection 2 which was stressed upon by the court in this case was that the role it plays in helping the court reach a correct and balanced decision regarding the sentencing. Till the decision regarding the guilt of the accused is reached, the courts are occupied with facts which have a bearing only on the guilt or innocence of the accused, and they have no scope to judge the implications of the sentence they seek to impose subsequent to the conviction. Thus, section 235 subsection 2 not only provides the parties a chance of being heard before a sentence is passed, but also provides the court with a valuable opportunity to be better informed before passing a sentence. In order to summarize this particular module, we need to keep the following things in mind. That the function of the criminal justice system does not end with a conviction of the criminal, but it also proceeds as to how a criminal is sentenced. Section 235(2) of CRPC 1973 provides that once an accused is convicted of an offense, the court must hear him unless the court is proceeding on the line of probation. The court must hear him on the question of sentencing and then pass a sentence. It also needs to be remembered that section 235 subsection 2 bifurcates the criminal trial into a pre-conviction and a post-conviction phase, with both phases being equally important. Though Section 235 subsection 2 does not make any specific mention regarding adducing evidence, it has been held that either of the parties can adduce evidence and the court should generally grant a permission in that respect. The provision of pre-sentence hearing under Section 235 subsection 2 are fundamental and indispensable in the administration of criminal justice. Non-compliance results in implicit and inherent prejudice to the accused, and any non-compliance will not be considered a mere technical irregularity which is curable under Section 465 of CRPC. In fact, any kind of non-compliance with Section 235 subsection 2 will vitiate the entire order. That would be all. Thank you.